and then start. Right, might as well get started. Good afternoon. By way of introduction, my name is Christopher McCauley and I'm a barrister at Guildford Chambers. I'm a Chancery barrister. I specialise in contentious probate and the law of real and personal property. And at the outset, I'd just like to thank you all for joining us for this webinar today. I will try and keep the webinar quite succinct, so I aim to get it completed within 30 minutes, as I appreciate that you're all pretty busy people. And if you have any questions regarding the webinar, then please feel free to email me at the address on your screen after the webinar, or if you just want to say hello, also that's always nice, or provide some feedback, that's always great. However, as always, if you have any questions about your individual cases, I'm more than happy to advise you on those and would be delighted to do so on a formal basis. But if you're asking me questions about in relation to today, it needs to be about the webinar rather than your cases. Right, so if we get started, some of you will be aware that this is the second webinar that I'm doing in a series of webinars on proprietary estoppel. Others of you might not be, but in the last, for those of you who were in the last webinar, you may recall that I made a point about, oh, and also if any of you did miss the last webinar, you can watch it on Guildford Chambers YouTube channel. But for those of you who were in the last webinar, you may recall that I made a point about you have a number of different elements that you have to satisfy in proprietary estoppel, but i.e. Assurance, reliance, and detriment. But even when you've established those elements, you have to then stand back and look at the matter holistically, or look at it in the round, as Lord Justice Robert Walker, as he then was, said in Gillett and Holt, and consider whether it would be, so when you're standing back and looking at it holistically, you need to then consider whether it would be unconscionable for somebody to be able to resolve from the promise, or whether it would be unconscionable to allow somebody to resolve from the promise. Now, you'll also notice from the slide that I've put up that that Lord Justice Robert Walker made a number of points in this passage, but one of them was that they're not, the individual elements aren't watertight compartments. They often feed into one another. So although for the basis of this webinar and for the basis of submissions, people usually break them down into individual elements, there is a significant degree of overlap between them. For example, the assurance may affect, well, for example, the example he uses is that the quality of the assurance may affect whether it was reasonable to rely on that assurance. And another extremely important point to remember whenever you're looking at proprietary estoppel is that what we're looking at is whether something is unconscionable, but we're doing that on a principled basis. So we're doing that by applying the relevant criteria that has to be satisfied. But the idea of unconscionability permeates throughout the principle that we're looking at. And I've just used this, just put this slide here just to remind you of that point. Now, moving to our first topic that we're going to discuss today, that is the topic of reliance. In the case of Campbell and Griffin, Lord Justice Robert Walker, as he then was, who, if you're familiar with proprietary estoppel, you realise just how important he is in shaping the law, made the point that when we're talking about reliance, what we're really talking about is an issue of causation. And this point has been made by a number of judges. So, for example, Lord Justice Bolcombe in Whaling and Jones made the same point. In James and James, His Honour Judge Paul Matthews referred to a sufficient, although not necessarily exclusive, causative link between the promise relied on and the detriment. And also in the case of Davis and Davis, Lord Justice Lewison stated that there must be a sufficient causal link between the assurance relied on and the detriment asserted. But the question that arises, because although we have all of these references to there being a causal link between them, the question that really arises as to what is the correct approach to causation? What is the test that one should apply when considering those questions? And the Professor McFarlane, in his seminal book, The Law of Proprietary Estoppel, argues that the test that we should be applying is a but-for test. However, you'll see from the slide that hasn't really, well, at least Lord Neuberger hasn't accepted that, as he stated, albeit in relation to a estoppel by representation case, that what the claimant has to show is merely that the representation was a significant factor that he took into account when making his decision. Further, if one looks at cases such as Whaling and Jones, which in particular Lord Justice Bolcombe's decision in that case, you'll see that Lord Justice Bolcombe sets out 3 principles in that case. And one of those principles was that the promise relied on does not have to be the sole inducement of the conduct. It is sufficient if it's an inducement, and I'll come back to that case in a moment. But instinctively, at least to me, I find the idea of the test being a contribution to be more attractive, because rather than the but-for test, as the contribution test has a lot more flexibility to it. And I think that's needed when you're looking at equitable principles, and you're looking in particular in relation to proprietary estoppel cases, because they're so fact sensitive. However, I do appreciate that that would require some qualification, because but I think that I think that's actually already been achieved by the fact that you have, or achieved to the extent by the application of unconscionability, because it gives that added layer of protection that you don't have in other areas of law where you see causation tests. I.e., in proprietary estoppel, you have the question of fact in relation to whether an assurance was the cause or a cause. So it was the cause or a cause. And then you have 2 more questions, i.e., is it reasonable and would it be unconscionable to allow the person, is it reasonable to rely on, or is the reliance reasonable, and would it be unconscionable to allow the person to resolve from it? And feeding into that last question is going to be a consideration of whether whether it was material, substantial, or trivial, whether it was a material, substantial, trivial cause. Now, moving on to our next slide, and I apologise if you're hearing that it's keep beeping. It's just as people are joining. There's a great deal of confusion that has arisen in this area of law due to one of Lord Denning's cases when he was sitting in the Court of Appeal, called Greasley and Cook. And this decision's caused quite a bit of controversy. And one can see that confusion from the cases that cite Greasley, as if you look at, say, for example, Southwell in Blackburn, Lord Justice Tomlinson in that case made reference to Greasley being a case about the onus of proof concerning detriment. And presumably the reason for that statement, the reason that statement was made was because in Greasley, Lord Justice Dunn actually, it says in his short judgment that the only question is as that the court had to consider is as to the burden of proof of the detriment. However, that is not the way that the case has been interpreted. And Lord Justice Stuart Smith, in the case of Stevens and Cuttings Limited and Anderson, stated that what Lord Justice Dunn had said in Greasley was not actually correct, because if you looked at the decision, there was ample evidence that Miss Cook had suffered detriment. And if you read Greasley, Lord Justice Smith is plainly correct. Further, as was pointed out by the Court of Appeal in Stevens and Cuttings, the actual ratio of Greasley, if you read it, is that where you have a representation which is calculated to influence the conduct of a reasonable man, the presumption is that he was so influenced. So if there is a presumption, it's actually in relation to reliance and not detriment. Further, as Michael Barnes QC points out in his book on Estoppel, what we're actually talking about here in relation to the Greasley is the mental element of reliance, is you still have to prove whether you took or omitted to take action on the basis of the assurance. And the point about Greasley relating to reliance has been made in a number of cases. For example, in Whaling and Jones, Lord Justice Balcombe stated that Greasley is actually about the inference of reliance. A similar point was made by Lord Justice Slade in Jones and Watkins, and by Jonathan Parker QC, sitting as a deputy judge in Coombs and Smith. Therefore, at least in my opinion, and also appears from the authorities, Greasley should be understood as referring to reliance. In Lord Denning's comments about detriment, really have to be viewed as obiter. But just before we move on from Greasley, it's worth noting that Lord Justice Neuberger, in the case of which, as I said before, is a Estoppel by representation case, Stereo and Hutchinson, has questioned whether there's a presumption, whether the presumption exists at all. So it's worth reading his comments on that about how he views the case, because he seeks to limit Greasley quite a bit. But as you may recall, a moment ago I was saying that we'll come back to the case of Whaling and Jones after we've discussed Greasley, and the reason for that is that Whaling and Jones is one of the rare cases where reliance wasn't proved at trial. And the matter was subsequently appealed to the Court of Appeal, and the Court of Appeal applied Greasley and found that reliance could be inferred. And the question, therefore, became whether the defendant was able to show that the claimant did not rely on the promise. Now, the case is interesting for a number of reasons. Well, the primary one is that the claimant had made a number of concessions in cross-examination that he would have stayed with the promisor had the promises not been made. And I think he said something along the lines in whatever business venture he would have had. And but in an examination in chief, in response to a question that was put to him, it said that he would have left the promisor if he'd been told that the promisor was going to resolve from the promise. So there were two arguments that were run on appeal, and the first one was that his answer to the question in cross-examination had been about their personal relationship rather than that he would have continued to work for pocket money. But the more interesting point is the second one, because what was argued there was that he was that the question that had been put to him in cross-examination was based on the promise not having been made. But the question that was put to him in examination in chief was that the promise had been made, and what would he have done had the person told him that they were going to resolve from the promise. And the Court of Appeal agreed that the question that was put in examination in chief was the correct question. because and said that what you need to ask is, what would you have done if the promisor had told you that they were no longer going to keep the promise? Now, that decision has been heavily criticised by academics. There's a number of them who do not like it on the basis of the idea of causation that it puts forward. But it still stands, and it has been applied in subsequent cases such as Walton and Walton. So turning to our next slide, I have set out a very illuminating passage from Lord Justice Robert Walker, as he then was, judgment in Gillett and Holt. And what I intend to do is just extract the key points from that passage. The first point to note, which is an obvious one, is that the detriment's required. Now, the detriment's a necessary component, and we know that that to be the case from cases such as Fawner and Major, which Lord Walker obviously gave one of the leading judgments on. But if one thinks about this point from a theoretical or a principle perspective, it's clearly both logical and desirable that it's a necessary component. As although I appreciate that there's a morality in keeping promises, it's not enough to interfere with the exercise of property rights. Something else is needed, and the factor, in my opinion, that justifies equity's intervention here is detrimental reliance, because it's the detrimental reliance that makes it unconscionable for the person to go back on the assurance. So it's, as a point of principle, it's clearly correct. Now, I'm going to jump around the slide a little bit. I'm going to take it in the order that I want to take it, rather than the order it features on the slide or in the judgment. But the second key point is that Lord Justice Robert Walker was saying that you need to plead detriment that you're relying on, and obviously the obvious reason for this is the other side needs to know the case that you're making. And he also went on to and that point was also made by Lord Justice Slade in Jones and Watkins. And the other point that he puts here is that he makes here is in relation that you also have to prove the detriment, which clearly, or I would think the reason why he's making that statement is because of Greasley, just making it clear that that's something that still needs to be proved. Now, the third point that I want to pick up on from the slide is that it is, which in my opinion is actually a very important one, is that detriment does not need to involve the expenditure of money. And there are many different ways in which detriment can arise. But what one is doing when you're considering detriment or approaching the questions of detriment is looking at whether it would be unconscionable to allow the other party to go back on the assurance. And to illustrate the point about it not having to be financial, if one considers the case of Henry and Henry, which was a Privy Council case, you'll see in that case is important for a number of reasons, and we'll come back to it in a moment. But you'll be observed in that case that their lordships held that the claimant would suffer detriment if the defendant was free to resolve from the promise, because as he deprived himself of having an opportunity to live a better life elsewhere. And this loss of opportunity type detriment is something that pops up quite a lot, or you see it pop up quite a lot in the farming cases. As you'll often see in those types of cases, that there's an assertion that someone has positioned their life on the faith of the assurance made, and as a result, has not pursued either educational or other career opportunities, and that it would be unconscionable to allow the other person to go back on their promise. And the positioning your life argument is quite an interesting one, because there's a number of counterfactuals that can arise in relation to it. So, for example, the person may have lost an opportunity to pursue a more profitable career elsewhere, or they may have lost the opportunity to pursue a job that they enjoyed, that they really enjoyed, or a career that they were interested in. But there's another point which I think is more substantial, which you see in those cases, because in a lot of those cases, you'll often have a situation where there's this, or you often have a situation where the person is, as a result of positioning their life, ended up working, say, 30 hours a week, working extremely long hours, say 60 hours a week for 30 years. And that's going to have an obvious impact on not only their lifestyle, but also their social and family life. If somebody's working a 70-hour week, it's obvious that that's going to have an impact on their life. And when you think about that point, someone might be prepared to make those sacrifices in order to obtain a piece of property that they can, for example, give to their children, because they're relying on a promise that's being made to in order to obtain something tangible that they can pass on to their children. But if they'd have known that somebody was going to go back on their promises, they might have chosen to lead a completely different life, or have a more reasonable work-life balance. And as we all know, you only get one life. So that the impact that has is, I think, quite a substantial detriment, because you can't get that time back, and time is one of the most important things that there is. There's also a very interesting, or there's an interesting counterfactual point that arose in the case of Guy and Guy. As in that case, the judge had found that had the claimant been told essentially that the promise was going to, had he known, he could have gone off and set up a viable farming business elsewhere that he could pass on to his sons. But due to his age, that wasn't now realistic, because as you get older, the less time you have, and therefore he'd suffered, with less time you have to make the business a success, and therefore he suffered a detriment. The next key point to take from this slide is that the detriment needs to be substantial in nature, and this point was also made by Lord Justice Slade in the case of Jones and Watkins. But you'll see from the slide that what Lord Walker's talking about here, in the way that you test whether something's substantial or not, is by considering whether it would be unjust or inequitable to allow the assurance to be disregarded. The final key point that to extract from the slide is that detriment must be judged at the moment when the person who's given the assurance seeks to go back on it. And you can. There's a passage that's quite regularly cited in relation to this point, and was cited in Fauna and Major, which is from Lord Justice Hoffman's, as he then was, decision in a case called Walton and Walton, about the retrospective nature of proprietary estoppel. Walton and Walton is an unreported case. It's quite difficult to get hold of, but it's worth reading if you get the chance. And the point about it being a retrospective exercise feeds into our next slide, because which I hope will be obvious, the point that in a moment, because when you're considering whether someone has suffered detriment, as was explained in Henry and Henry, the Privy Council case I mentioned before, you have to weigh the disadvantages that the claimant has suffered by reason of his reliance against the countervailing advantages which is enjoyed by reason of that reliance. And Wilkin and Gailey, in their book, make the point that balance between the two, i.e. the advantage and disadvantage, can fluctuate over time. And that point is probably most obvious in the cases where somebody has improved a property, but they've lived in that property rent free, that there's the fluctuation of the detriment that's suffered. Now, again, another interesting point arose in the case of Guy and Guy, which, in relation to the countervailing benefit, in relation to countervailing benefits, because in that case, the claimant had received a place to live, but the court found that it was something that had been given to him as a result of his status as a family member. And you can also see in a case called Southwell and Blackburn that in that case there was a provision of rent-free accommodation, but that was viewed by the court as an incident of the cohabiting relationship between the parties, rather than an advantage that had been enjoyed in Reliance as a result of the assurance. And these cases, at least in my opinion, demonstrate that when you're considering the point about countervailing benefits, one has to consider whether the advantage stems from relying on the assurance or whether it results from relying on an external factor. Now, as we move to our final slide, we've already discussed loss of opportunity, but I should just make the point in relation to loss of opportunity that there's a number of different ways in which that could arise. And there is a number of different ways in which it does arise in the case law. And it's quite interesting how that principle applies to detriment. But a very important point on this slide is that the detriment does not have to be a benefit to the other party. So in the most obvious example, or the case that most clearly demonstrates this, is the case of Crabbe and Aaron, District Council. Because in that case, the claimant had sold part of his land without reserving a right of way over the land. And he, in doing so, he'd essentially he had rendered his land as being landlocked. But he did so on the belief and an encouragement that he would be granted a right of way over the adjoining land. And as such, an equity was found to have arisen. And but if you however, if you consider the facts of that case, it is very clear that there was the detriment had no link at what the court's looking at is the detriment only. It's not looking at whether. So it's not looking at whether the other person has received a benefit. So we see the opposite of unjust enrichment essentially in proprietary estoppel, because, say for example, in unjust enrichment you're looking at the benefit, whereas in proprietary estoppel what you're looking at is the detriment that the promisee would have if the person was able to resolve from the promise. And I think that's probably best illustrated by Crabbe, Aaron, and District Council. Another point that I should just also mention, which I haven't put on the slide, is that although the assurance has to relate to obtaining an interest in land, as there has to be a causal connection between the detriment and the assurance, the assurance that the person will obtain an interest in land, the act of detriment does not, or the actual act that gives rise to the detriment doesn't have to be something to do with the land. So I think this is probably best demonstrated in what I term, at least, the carer cases. So where you've got, the name of the case escapes me, but where you had a lodger who was essentially caring for an old couple, because in those type of cases, the person's doing nothing in relation to land. What they're doing is they're helping somebody and they have an expectation that they will get something in the land, but the actual acts of detriment that they're doing has nothing to do with the land. It's just to do with the person. Campbell and Griffin is the case that I was thinking about. So the final point that I just want to cover is in relation to whoever's just come in. We're on the final point. So it is in relation to the context in which you it is a point in relation to context, and I think that this point is probably best demonstrated by the case of Pascoe and Turner. And those of you who aren't familiar with that case, basically what happened was Mrs. Turner had lost her husband, and she became Mr. Pascoe's housekeeper, and a romantic relationship blossomed between them, and they began cohabiting as man and wife. Unfortunately, however, Mr. Pascoe had an affair with another woman, and the relationship with Mrs. Turner broke down. And he'd said words, or at least the judge found that he'd said words to the effect of "the house and all the contents are yours." And in reliance on that statement, Mrs. Turner had used. Sorry, I should just give a bit of context. Mrs. Turner was in her sort of mid-50s or late 50s. She was a widow. She had a pension, and she had very limited means. So, if I remember correctly, she had £1,000 in savings. And in reliance on the representation that was made to her, she spent £230 on fixtures in the property. She also bought various other items like carpets and curtains and furniture. And by the time that the matter had got to trial, she only had £300 left. And in those particular circumstances, the Court of Appeal held that the detriment was substantial because in the context of her case, the detriment was substantial to her. Now, instinctively, I have a bit of a problem with the idea that purchase of curtains and furniture necessarily cause detriment because they're movable items. But I suppose theoretically, if you reneged on you'd have the benefit of those somewhere else. But I suppose theoretically, if you reneged on the promise and then you had to move to a flat, it might be that you can't use them in the flat, or that you have to sell them for less. But there was also in that case there was also a lot of other things like that. So she'd been spending money on fixtures and so forth. In any event, I agree with the principle that's set out in that case, which is that you have to take into account the context or the facts of the case when considering whether the detriment is substantial. I hope that has been helpful to you all, and I hope you've enjoyed the webinar. As I said, if you have any questions, then please feel free to email me, and thank you for joining us. I will be doing another webinar on proprietary estoppel, probably covering guest when that's handed down. Okay, thank you very much. Bye.